So let me just tell the people that are there that what we're going to do is I'm going to go through a couple of areas that I've got preset, and you know, just like we've always done with the brown bags, and I'm going to lay out what we're going to talk about, and then I'll be obviously answering questions throughout the day. We're here for 2 hours. If it doesn't take 2 hours, great. If it takes longer than 2 hours, I'm fine with that as well. So what we're going to talk about today is you guys are getting a whole bunch of new forms. And so I want to kind of go over them. There's going to be some conditional forms. There's going to be some 2 new forms. And then there's going to be some revised forms, a couple of which I'm frankly very excited about. I think they're going to help with risk management. I'm going to do a little quick introduction to the new RPA, which comes out in December. Then I'm going to jump into some new and proposed laws. I'm really happy that your government affairs director is with us today, because he may have more insight than I do on some of these laws. I've got a couple of changes that are taking place on the Americans with Disability Act. Want to kind of bring you up to date on, because they're targeting real estate offices. And so I want you guys to be aware of what's going on. I talked to Ed Zorn yesterday. He's the attorney for the multiple listing service, and I updated a couple of things that I want to bring you up to date on with the MLS, so that you guys are aware of what's happening and what's coming down the road. I unfortunately have a couple of Department of Real Estate defense cases, and have done a couple of programs with the Department of Real Estate people. So got some things to tell you about there. And then I want to spend a good chunk of the day going through risk management. And why do I want to do that? I attended a meeting last week. I've attended 3 risk management meetings from the CAR and or NAR in the last couple of weeks. And a woman who I consider to be one of the top risk management people in the entire state made a comment that everybody agreed with, unfortunately, and that is based upon the bad conduct of a number of you, not you guys, because you're all wonderful and that you're here, and I'm sure you're the best, but there's a lot of, how do I say it, bad behavior going on out there. And then there's a lot of things that are being done simply because the market is requiring you guys to do certain things, waiving contingencies, things of that nature. And we're going to dive into what I think you can do to protect yourself. I've done a couple of risk management programs recently, and talked to a couple of my friends, and handled some things on my own. And so I want to kind of spend at least 45 minutes, if not longer, just going through some things to hopefully help you guys document your file a little bit better. So I'm John Giardinelli. I've been association counsel for a bit of a time now. I'm broadcasting live from Franklin, Tennessee. That's my front yard, and I live in a kind of a nice rural area, and be coming back and forth, but I still practice law only in California. And so we're going to talk about California today. So a couple of things regarding forms. The Department of Justice and the the National Association of Realtors settled a dispute a number of months ago. And as a result of that dispute, there are going to be some changes relative to the way the multiple listing service functions. In the interim of them working out the rules to carry out the terms of that settlement, we had an election. And in that election, the former president lost and the new president won. As a result, among many, many other things, there was a complete changeover regarding the people that were handling putting together the final settlement and the final set of rules that will be passed on to you guys through the multiple listing service. So in order to get out in front of some of the stuff, the CAR has come up with 2 conditional forms. One of them is called the Buyer's Broker Compensation Disclosure Form, and the other is it's also a buyer broker disclosure form, and I've misplaced it, but oh, here it is. It is an anticipated broker compensation form. The issue, which has not yet been resolved, is when are you going to be required to, in writing, disclose to your buyer the exact amount or the anticipated amount of your compensation? There are going to be several rules, but because CAR doesn't know, they've gone ahead and prepared both forms. They won't release the forms until they know that the settlement has taken place. So again, film at 11. I just want you to be aware that these forms are coming down the road. And in talking to Ed yesterday, the final resolution, frankly, could take place tomorrow, or it could take place 3 months from tomorrow. We don't know. Connie doesn't know. The board doesn't know. CAR doesn't know. They're working on it. And when it gets to a final point, it'll then be submitted to the judge. NAR will then get the word out. And of course, CRMLS will let you all know what the final rule is going to be. That rule applies along with some other rules dealing with the lockbox and the kind of access you're going to need to provide. It requires that you no longer search by compensation only, and a couple of other rules, which again, no sense in keeping you guys in suspense right now because we don't know what the final rules are going to look like. There is a form that has already been released. The federal government has decided that property managers and attorneys who collect rent are considered to be bill collectors. And for those of you that have ever had the joy of getting a letter from a bill collector, you know that there has to be a warning reminding you that there are restrictions on what bill collectors can say and do. Well, that same warning now needs to be given by both property managers who are collecting past due rent and attorneys who collect rent on behalf of clients. That form, which is called the CFPB, Disclosure of Potential Eviction Protections, CFPB standing for the Consumer Finance Protection Bureau, probably will be sunsetted in July when all the other no eviction rules are sunsetted, assuming that that's what takes place. And Adam knows better than I whether or not there'll be any extensions. I have not heard any scuttlebutt that any of those rules are going to be extended. The good news is that CAR already has this warning for you, and it is bundled with all of the eviction forms that you would use to evict a tenant and collect rent. So I'll give you the list of in a minute of those forms that they're bundled with. But if you are using CAR forms to evict a tenant or to try and collect rent or any of the other things that go with the bill collection aspect of a property manager, that form is already available to you. According to CAR, they made it available a couple of days ago. Now, there are going to be 2 new forms and about 12 other forms revised during the week of June 21st. I am going to do a newsletter once all the forms have been finalized, and I will get that to Connie for distribution, however Connie distributes newsletters and things of that nature. So we'll get that to you, and I'm going to go over them really quickly. There are 2 brand new forms that are coming out. One is a form that is being prepared in response to a new statute that goes into effect in July. It is the Fire Hardening and Defensible Space Advisory Form. As you know, Californians now need to make certain disclosures if they're in a high fire zone. if they are part of an area where certain defenses have been made in terms of how properties are protected from fires and floods and things like that. This is a very complicated form. We met a couple of days ago. It's not finalized yet, but the form will coincide with some things the state's going to be doing. So what's going to basically happen, and again, I'll go into a lot more detail when things are finalized, but essentially what's going to happen is that your NHD provider will be given certain information which the seller will then use to help fill out this form. And it is a two-page form that will advise the potential buyer if you're in a fire severity zone. There's some language regarding what the law requires people to do. And then, unfortunately, because of the way the law was written and its complication, there is also going to be some things that the buyer may end up having to do down the road, depending upon changes that are made to the topography and whether or not fires are going to be a problem in the area. And obviously, because you guys are in the Lake Elsinore area where you guys had those fires, and that whole area is still of concern, the Cleveland National Forest and the Ortega and all of that, and probably some areas out by Temecula. This is an important issue. So I'm going to take a little more time. I may actually, I'm trying to figure out what I want to do to make sure you guys are properly advised, but myself, CAR, there'll be plenty of writing. What I'll try to do is be your clearinghouse. I'll get as much information, get myself as educated as I can, and then we'll pass on information through Connie and the board the best that we can. The other form I really like, in fact, I wish I had it available right now and I could use it in a case I'm dealing with, and it's a transfer of listing form. It's a form that will have to be signed by the principal that is approving the fact that the agent is moving from office A to office B, taking the listing with them. It is, even though it's called a transfer of listing form, there's a section on escrow. There's a section for making sure that the broker who is transferring the listing to the new broker is absolved of any future liability because the new brokerage doesn't handle things correctly if that were to take place. So there's a release, there's language dealing with how the file should be transferred. I have a case like this right now, and the problem is the brokers are arguing about who gets commission, and that's well and good. I understand we all want to be paid, but there's this buyer out there who's not being protected and the seller who's not being protected. And so what everybody needs to remember is that this is about the client, not necessarily about the agent. So a couple of other forms I'm just going to touch on real briefly that are being revised. The lease listing agreement is being revised, and what I like about it is there's a section in there to elect how you terminate the agency. So for example, if Adam were to rent out my house for me, is his agency terminated once the lease is executed, or is he going to manage the house for me? Is he part of a property management group? So there's going to be language in the form for those of you that do property management as to when your obligations will expire. There's a property images modification because you guys are using drones and aerial photography now to a greater extent than ever before. And so there's going to be some language in there in the PIA, it's called. The referral fee form is being modified to make it clear that unless otherwise agreed, if you are earning a referral fee, that it is earned when escrow is open. Now, you may want to change that and make it when escrow closes, but the default provision in the referral fee agreement is going to be when escrow opens. They're making a number of significant changes to your listing agreement during the week of June 21st, and I really like them. There is no statewide rule regarding days on market. right? CRMLS has its rule for coming soon, has its rules for how you count days. And so there's a disclosure in the lease that simply says, depending upon where the property is placed for listing in CRMLS, in your case, there is no set rule. Also, there is no set rule for clear cooperation. For you guys, it's 21 days. Here in Franklin, Tennessee, it's 30 days. Different parts of California have different rules for how you deal with clear cooperation and coming soon. So there's a place dealing with that issue as well. There's language that I really like dealing with the so-called buyer letters or love letters or whatever your office calls them, and talking about the warnings that, you know, they could have fair housing implications and things of that nature. So again, there'll be some language in your new revised listing agreement. And then of course, depending upon the settlement with the Department of Justice, there'll be some references to disclosure of compensation and the like. There is going to be a change to the statewide buyer advisory. Now, this is my personal opinion, shared by a lot of risk managers that frankly don't want to see y'all get sued. And that is, I think this is one of the most underutilized forms in the arsenal of risk management forms that you guys have. I know it's 14 pages, but it has all kinds of good language. They're modifying it a little bit to clear up the table of contents so that it's easier to find different kinds of disclosures depending upon what you're talking about. And then they're going to add some language which hopefully won't affect you guys unless there's a really big earthquake dealing with coastal properties. But take a look at that form. I don't have time to go into it today, but whenever I do a risk management class, I really spend a lot of time talking about that form because I think it's really really a good risk management tool. And if you give it to your clients early enough, and you know, maybe go over the table of contents, particularly if it's something in there that's relevant to the transaction you're handling, because it talks about things like, you know, the evolving market and the swings in values and things like that, all kinds of cool stuff. I just really think you should become very familiar with it. And then the last form that I want to talk about right now is the seller's purchase of replacement property. That's the contingency that says that, you know, the buyer is going to wait a certain period of time while the seller goes and finds replacement property. And the choices are in the current form that they open escrow or that they close escrow, and then the contingency is removed. There's a third element that's going to be added, which just is that the buyer finds a suitable area or a suitable property. So again, keep that in mind. Those forms come out on June 21st, and I'm going to write a newsletter, get it over to Connie, and then we'll see how she wants to handle things to make sure you guys all feel comfortable. Well, guess what, kids? You're getting a new California residential purchase agreement and joint escrow instruction along with whatever forms there are going to be in December. And why I say it that way is because the RPA currently refers to about 60 forms. And so because of this complete revision of your purchase agreement, they're going to have to either sunset, revise, or do something to make these the forms that you guys use with the current RPA sink in. A couple of forms actually are now inside the RPA, so they won't be useful anymore to you as secondary forms because they'll be part of the RPA. So most of you are aware already that you guys are coming up with a new RPA, so I'm not going to spend too much time on it because we're going to do classes. I know either Barbara or whoever's handling classes for the RPA for you guys will touch on these things. The CAR is going to do classes. I'm going to do it from a risk management perspective. There'll be plenty of there'll be plenty of programs for you to attend. My warning to you is this: it's going from a 10-page form to a 16-page form. It's going from a form that kind of is all over the place in terms of disclosures and deal points and all of that, to a much more organized format, but it's going to take some time for y'all to learn it. If you wait until December, Zippy is going to do away with your old form. Come whatever day the new form is published, probably in the first or second week of December, there will be no current RPA on your program. It will only have the new form. So if you wait until December to get educated, you're probably going to be waiting too long. So my suggestion to you is more than likely the training will start in mid to late August, and make sure you take advantage of it. Michael, in order to get the form, go to car.org and go to forms. And there's a version of it there. Just understand that the committee that's working on it is getting hundreds of comments about it. You know, they've been working on it for 2 years, but of course everybody waits till the last minute. And so they're getting hundreds of comments. They are meeting on a weekly basis. Neil told me last week, Neil Kalin, who writes, is primarily charged at CAR with writing up your forms. Plus they're dealing with all the COVID stuff that I'll talk to you about later. And so they're meeting weekly. So whatever form you look at, while it's going to be substantially similar to the one you're going to get in December, is not necessarily the final form. Okay? So just remember that. The biggest change is going to be that in the first 2.5, 3 pages of the form, they've taken all the negotiating points. So things like the purchase contract. Well, I don't know if you can see it. I'm going to show it to you. Can you see that? Can you see that matrix? That's my handwriting, by the way, ignore it. But if you see that matrix, that's the first 3 or 4 pages. So things like the purchase price, everything's going to be summarized right there on the spot. The all of the occupancy types are going to be summarized all in that section. There's going to be summaries of all the final verifications, and all the contingencies are going to be lined up in one place. All of the possession issues are going to be lined up in one place. The documents and fees and who's to pay what, all summarized in one place. And then they're going to have a much more expanded section dealing with things that go and stay. So there's going to be references to wine refrigerators and microwaves and video components and security camera equipment, and all that stuff is going to all be together. And then in those areas where it's relevant, it will refer to the paragraph that defines that stuff. But most of the checking off of boxes and most of the filling in of blanks will be on the first 4 pages. Now, for those of you that enjoy a little danger, you'll just probably look at the first 4 pages, forgetting that there are 12 additional pages. The rest of the contract is pretty much pre-printed. So as you learn it, you're not going to have to fill anything out for a lot of these pages. Obviously, where the liquidated damages clauses are and where the arbitration clauses are, they're going to have places for initials, and there's a couple of places to check off some boxes as you go through. But a good chunk of this, and I'm looking at it right now, a good chunk of it is just pre-printed. So as you read what's in it and you get a feel for how it's laid out, you're not going to have to fill out a lot of blanks. You're just going to have to sit down with your client and make sure that they understand what this language is. You're not interpreting the language, that's a lawyer's shop. But what you're doing is going through, and as you become more familiar, you're going to be able to, frankly, not have to fill out too much. A couple of other things that I like. Now, I'm a lawyer, I don't sell real estate, but some of the things that I like are, I always heard in phone calls that I get, you know, that, well, the mediation clause isn't applicable because they didn't initial the arbitration box. The mediation clause was applicable. It's just that they put it in the box with alternative dispute. They've separated out now so that mediation is its own, pardon me, its own standalone paragraph. And then the section on exclusions and arbitration is its separate section, and that's what you'll initial. Also, for those of you that do land or probate or all of the other contracts that CAR has available to you, they're all being sunsetted. So what you'll do is you'll use this contract, and then each of those types of contracts are going to have an addendum. Right now, there is a probate addendum, so you could use the standard RPA along with the addendum. That's going to be true of all of the other purchase agreements that CAR has available. So if you're going to do something besides a residential 1 to 4, if it's income producing, if it's vacant land, if it's commercial, whatever it is, probate, you're going to be able to simply find the appropriate addendum, fill that out, and then that'll integrate with this RPA. So again, there's a lot that's changing and a lot that's not changing. And that comes out in December. So let's see here if I have anything else I want to point out about forms. Daniel, are there, it looks like there's a few questions about forms. So you guys might want to take a look at the Q&A. Somebody, it looks like Sylvia put it up there for you. Sylvia, you're awesome. So you've got that. I don't know if there's any actual questions. I don't see any. If there are none, I'll move on to the next issue. Okay, let me switch gears here real quickly. Now, a couple of some new laws, and I'm not going to go over all of them. CAR put together a matrix of all the new changes. It is 63 pages long. The legislature was busy, and as Adam can point out, they're even busier this year. Some of the laws are bad. I feel bad for employers. There's a lot of things that are coming down the pike that are going to make it difficult for employers, certainly exposure to more liability. A couple of laws that are coming or are being discussed right now, and Adam, feel free to jump in if you'd like. I know that there's a lot more, but two laws that caught my eye. I attended a meeting with the CAR's lobbyists not too long ago, and one is as you know, there is a really big push on fair housing, and I think that's perfectly fine. People that can afford a house ought to be able to buy a house, shouldn't matter what color they are or any of the other classifications that are protected. People that can afford a house should be able to buy a house. If they can afford the lease, they should be able to lease a property. A lot of realtors don't even realize that they carry with them certain prejudices. Maybe it's where you grew up, maybe it's when you grew up, maybe it's how you were raised. And so you have these sort of implied biases that you don't even realize sometimes. And there's going to be a law, I don't know if it's passed yet, I know CAR is sponsoring it, that will, when you do your renewal for your DRE license, you will have to take a implied bias class. So be prepared for that. It's not going to hurt you. You can do it right now if you want. NAR has a video on its website. It's about 52 minutes long, and it covers all kinds of really good stuff. You can go there. And the reason it's important, number one, it's the right thing to do, but also the penalties for fair housing are severe. many of you attended the brown bag, or excuse me, the legal panel that we did about a month or so ago. Adam was our moderator, and one of our speakers was Brandon Butler, who's an attorney with California Department of Fair Housing. And the penalties and the fines for fair housing violations are significant. And you may be violating the rules and not even know it. So that law is being considered. I suspect that we'll see it sooner than later. Another law that's being considered, and it's a 2-year bill, so don't be looking for it anytime soon, but just to show you what's going on up in Sacramento right now, the transfer disclosure statement, if you once you get it to the buyer's side, the buyer then has 3 to 5 days to rescind, depending upon how it was delivered, either by mail or by email or in person. They're talking about extending that time, so 3 days would become at least 5, and 5 days would become at least 7. So you may see that change in the law fairly soon. A couple of other laws that I want to bring your attention to, and then I'll jump into another topic. All of your, unless they violate the old law under current California law, appraisers are considered independent contractors, as are property inspectors. Additionally, in many homeowner associations, HOAs, they try to restrict rentals. Now, I'm not talking about the less than 30-day Airbnb type rental. I am talking about rentals and 30 days or more. And a lot of HOAs don't want rentals because they think that renters don't take care of their property as well, violate more rules, et cetera, et cetera. But because of the because of the housing crunch, the legislature passed a whole bunch of laws. The most significant is that an HOA must allow at least 25% of its units to be rented. So if I live in an HOA that has 15% rentals, there is nothing that the HOA can do to prevent me from renting my unit, other than some ancillary rules regarding behavior, who's to pay for fines, things of that nature. So if I have 30%, then you want to look at the rule, because there are some grandfather provisions in the rules as well. So that's a statute that's now in effect. You're entitled to a paper copy of your PACE disclosure under a new law in California. If you have co-signed a document that is required to be translated into one of the 6 language groups, for example, if you co-sign a lease and it was negotiated in Spanish, and therefore the contract must be provided to the tenant in Spanish, the co-signer is entitled to a copy of the language that he or she speaks as well. So if I'm a person who speaks Spanish and I guarantee a contract for another couple that speaks Spanish, I also am entitled to a copy of the language translation. They're going to be expanding the homeowner's Bill of Rights, and there is a if a tenant is in a property that's being foreclosed on, when they post the trustee sale, the foreclosing entity must also post the rights that the tenant has relative to that foreclosure. So there's a notice of tenant's rights that must also be made available to the tenant as well. I'm going to stop there. As Adam, you guys have a great GAD, and as Adam can report to you, the legislature is very busy right now. All right. Any comments or questions on that? Don't see any. So let's move on to a subject that might find its way finally to the Supreme Court. Some of you have received letters and or maybe even a lawsuit or a threat of a lawsuit because your website is alleged to not be ADA compliant. What happened is in California, California, along with Washington, Oregon, and some other states fall under the jurisdiction of the Ninth Circuit Court of Appeals. And the Ninth Circuit ruled in a case called Robles versus Domino's Pizza that your website is required to be compliant with ADA standards because it is considered to be nothing more than an extension of your brick and mortar office. So for example, in the Robles case, Mr. Robles was blind or is blind. He went online to order a pizza and do some other things online. And he could not because Domino's does not have their system set up to integrate with the systems that are set up for persons who are hearing impaired and or sight impaired. And therefore, he could not be treated equal to someone like me that would go on and order a pizza online. And the same thing holds true for reservations in restaurants and things that are for sale online. There's a case that was decided here in the 11th Circuit recently that made just the opposite ruling. It's a case called Winn-Dixie. And the court in Winn-Dixie actually pointed to the Robles case and said, we disagree with it, and ruled in favor of the business and said, there's nothing in the Americans with Disability Act that would require a business to have its website to be compliant with ADA rules. I think that's important because now we have two separate, very strong districts completely at odds with each other. So we basically have two sets of constitutional federal law, and that's the kind of case hopefully the United States Supreme Court will agree to hear and make a decision one way or the other. So if you have offices in other parts of the country or you do business in other parts of the country, you'll know what the law is. Also, and I'm constantly forgetting the name, so I'm going to look it up. I'm a member of the NAR Attorney Discussion Group, and we were warned recently about a group that's out there sending these demand letters. Some of you may have received them. You know, usually it has to do with someone who tried to get into your building, couldn't because the door jamb was a quarter inch too not wide enough or something like that, and they want money. Basically, I won't call it a shakedown. Oh, the heck with it. I'm going to call it a shakedown. And they don't give you any opportunity to fix anything. They just want money. Well, there's a group out there doing the same thing now with the website violations. So if you get a letter from an entity called Pursuit of Respect, make sure you let your insurance company, your company lawyer, somebody know about it, because they're sending out a standard template letter and they're demanding usually around $14,000 to go away. The trouble is, even if you were to settle it for $3,000 or $5,000, you're not necessarily out of the woods, because maybe another organization is going to come along and make the same demand. If anybody's interested, there are some standards that were approved by the Domino's Pizza Court, and I will be happy to send that link to Connie or to Daniel. And if there's only one or two of you, I'll be glad to send the link directly. So let us know, send us an email, and if you're concerned at all about your websites and you want to save a little bit of money, let us know. Okay. Next, MLS. Like I said yesterday, I had a conversation with Ed Zorn, who is an incredibly fine attorney. We talked for a little over an hour about all things MLS. So I want to just bring you current on a couple of things. They were toying with making Saturday a regular day, so that would count towards all of the days that you have to move. They've decided to postpone that for a little while. I don't know exactly when that date will become effective. The rule will go into effect eventually, but apparently they got a lot of pushback. So that is not in effect right now. They've been told by NAR, and they're working on the rules, that the MLS must also adopt some fair housing rules. So for example, if you were to put something in that they're going to be allowed to literally take down fair housing violations in the MLS, to report conduct, to do those kinds of things. So I don't know when those rules will be ready. They're working on them. There's also going to be some changes to the citation policy. I can tell you, based on a letter I saw yesterday between your professional standards administrator and CRMLS, which I was copied on, that new citation policy and your ability to appeal is going to be changed probably within the next 10 days. So keep an eye on it. As soon as I know what the final changes are, as soon as Linda knows what the final changes are, we'll get something out to Connie immediately. It's not going to be harmful, although they may do away with some warnings. From what I've been told, they're pretty tired of people having to be warned about coming soon. And it's interesting because I had a lunch with my personal realtor here in Franklin the other day, and they have the same problems you guys do. The only difference is they allow 30 days for coming soon instead of 21. But most of the rules are virtually identical, and their MLS does the same thing your MLS does. But more than likely from now on, if you violate the coming soon sign in some way, you're not going to get a warning. You're just going to get a fine. So be aware of that. If you get 4 citations in a calendar year, so January 1st to December 31st, if you get 4 citations, the 4th citation is going to go to the grievance committee, and your grievance committee will determine whether there should be additional fines, sanctions, whether you should be required to take classes, all that cool stuff. So that is an NAR rule. Don't blame CRMLS for that. But apparently nationwide, people are violating rules and trying to get away with a lot of stuff. And the problem is this: the MLS is nothing more than a big data bank, right? I mean, you guys put in a lot of data, and if the data is not accurate, then you guys are going to be frustrated. So in order to keep the data pure, these rules are necessary to make sure status changes get done on time, photographs get posted, all that kind of cool stuff. And so NAR said, look, 4th citation, send them to grievance because enough is enough. And brokers, the idea is that you'll join your agent because these are your listings. And if you're properly supervising, you knew about the other 3 citations, and you should have done something within those 3 citations to get your agent up to speed, and you failed to do that. So you guys can ride share down to the board for your hearing because you're going to be joining for a failure to supervise. I knew that there were a bunch of class actions. Ed told me about a new one yesterday. There are lawyers out there suing MLSs all over the place on the theory that the way you share commission is an antitrust violation. Those cases are pending in Illinois, in Florida, in Missouri. There's 2 or 3 on the seller side, where a seller is saying, wait a minute, I've listed my property with Carol and I've agreed to pay Carol 4.5%. But Carol is offering all of the other people in the MLS 2%, which means what? That I'm paying another realtor to negotiate against me, and I'm paying the buyer's side, although realistically the buyer's paying for it too, because the buyer is also paying for it in the cost of the house. And that's the buyer's side class action, is that because of these rules, I'm being asked to pay more for the house because the seller has to pay a commission. All of this, I've read the complaint on the seller side. I've not yet, Ed's sending me the other complaint, I haven't seen it. If you read it, which I'm sure you won't because you're too busy with, you know, competing with 37 other buyers for houses you're trying to get your clients to buy, but you would see that there's a clear misunderstanding of how you do business. The fact that a buyer who doesn't have the money to hire a realtor gets to pay for it through the purchase price of the house makes a lot of sense, because money buyers couldn't afford to hire their own buyer's agent. So again, these lawsuits are pending. They are all over the place. And while we won't see any changes probably for a couple of years, somewhere down the road, there's going to be some significant changes. I believe that the MLS, as you know it today, is going to look substantially different. I've had these conversations with Connie in the past, and I personally believe, well, take a look. Look at the MLS you guys have today compared to the MLS you guys have 10 years ago, and look how different it is today. And with technology changing as exponentially as it has and as quickly as it has, I suspect you're going to see more and more consolidation of MLSs, more and more sharing of information. I know Ed and I were talking yesterday here in Tennessee. There are very close-knit areas like up near Gatlinburg, the Smoky Mountains, where they don't share information, whereas in here where I live, which is just south of Nashville, we have the Greater Nashville Association shares a database called Real Tracks with all the other MLSs in the Nashville area, and something like 60% of the realtors in Nashville belong to it. And so, you know, you're going to start seeing that technology will change, and the way people's attitudes are going to change, and so forth and so on. So I think that's all I'm going to talk about on the MLS, unless there's any questions. Prepare for the MLS to take much stronger positions regarding violations, because in this market, things are, and I'm going to talk about that from the risk management perspective in just a second. So unfortunately, I do a lot of work with the DRE. I don't like it. It's sad, because that means that my client could lose their license to be a realtor, or to be a real estate professional, but it is what it is. So a couple of things. I was talking to the head of investigation regarding what they're seeing and some things. I just want to point out, these are just things that he and I talked about. I took notes and I put them in here. So we all know things are opening up. I know Adam has been busy with up to his neck in discussions with CAR regarding the negotiations that are going on between CAR and the state representatives regarding opening things back up again, normalizing open houses, normalizing the things that need to be normalized for you guys to go back to normal. And that's fine, and that's great. And it'll probably happen. It could happen, frankly, any day, where you're going to see announcements coming down from CAR. They are currently negotiating. Adam, unmute yourself if you want, if you have any additional information, but we don't have an answer today. We know that there have been negotiations. According to the CAR representatives, the people at the state level have agreed that you are essential, and that you should be going back to some level of normalcy in terms of showing property. But what that's going to look like as of this moment, we don't know. Why is that important? Because the Department of Real Estate is still enforcing those rules. So if you're caught not doing the things you're supposed to be doing, not providing the declarations you're supposed to provide, not sanitizing houses. I saw a Facebook post the other day, and I know the person, and the person that posted it is a wonderful person. And they were showing, I think there were like 6 couples lined up outside the house. Okay. Why not just send that directly to the DRE? Because if the DRE sees it, they're going to issue at least a citation. And if they think it's being done on a regular basis, they will bring the broker in under an investigation. So they're still enforcing, even though we expect, certainly by the middle of June, that things will be back to normal, very possibly even sooner. So one of the great reasons that you guys pay your dues is because you got people like Adam, and you got people at CAR working on this for you every single day. So just keep an eye on the website. Keep your eye on your emails, and you will be kept current. To answer your question, Corey, the couples were literally within a foot of each other. There was no time between the showings to get the house back and desanitized and all that stuff. Whether you agree with it or not, it's irrelevant. I agree with a lot of laws. I mean, I'm a lawyer. My job is to tell you what the law is and tell you to stay out of trouble, even though I may disagree with the law. But in the picture that I saw, these people were all bunched in, and they were going in as time would permit. Another thing that the DRE wanted me to warn you guys about again is, and I'm going to talk about specifically Zillow contracts and some other things, but there have been, and I know there's been some negotiation going on at the state level with CAR, but I've seen some contracts by organizations that have joined the MLS and or even the board, and their addendums to the RPA. And in those addendums, they attempt to waive certain disclosure rights. They use language like to the fullest extent permitted by law. I was asked to remind you that it is a violation of your obligation to waive a transfer disclosure statement in a transaction that is covered by a transaction by a TDS. So, for example, in a 1-to-4 where there's no other exemption, it's not tenants in common, it's me selling the house to you, we're not related, there's no tenants in common, none of that stuff. A transfer disclosure statement is required, and any effort to waive it is a violation of law, because the TDS, based on 1102 of the Civil Code, cannot be waived even by contract, even in a flip for investment purposes. Okay? Period. So that's Business and Professions Code 10176.5. It's asked to remind you, it is okay to get a referral fee. It is okay to discount your fees to your client, even to the point of going to zero, right? I can work pro bono for a client. You can work pro bono for a client. Nothing wrong with that. You can also earn referral fees, and there is a really good CAR Q&A on referral fees. But what you cannot do is you cannot get something of value if you are a settlement service. I have a case I'm working on right now where the realtor got a gift card from the escrow company thanking her for her business, and the Department of Real Estate has filed an accusation because she is getting something of value for that referral, right? So be careful about that. Nothing of value. Another area where that comes up periodically is, so I've hired Adam to list my house for sale. Adam knows that the market is insanely busy right now, and he doesn't want to waste my time looking at looky-loos. Plus, under the CDC guidelines, supposed to be pre-qualified. He doesn't trust anybody but the people he knows. So he says to everyone in the MLS, you must pre-qualify with Sylvia Garcia mortgage, okay? That is perfectly okay. There is no restriction on Adam doing that. However, if Adam does one of two things, he's in a world of hurt. If he requires you to use Sylvia Garcia mortgage, that is a violation of both federal and state law. Number two, if Sylvia gives him anything of value, and I don't know what that would be, could be a gift card. In the case I'm handling, she got 3 gift cards. One to Total Wines. I sure wouldn't mind getting a gift card like that. One to Home Depot, and one to Starbucks. I mean, $10, real small. That would be a violation, and that would get both Sylvia, if it's a broker-controlled escrow company, and would get Adam in trouble for accepting that. So I don't make the rules. I think it's dumb, but that was the rule, and so just be aware of that. So now, let me see how much time I have. Okay, I got an hour. Yay! So I'm going to spend the rest of my time, and it won't be a full hour, so I'm open to questions, talking about this market and talking about what I'm seeing. And I'm going to break it down into 4 or 5 separate categories. I want to spend a little bit of time talking about all of you that are practicing law without a license. I want to talk about waiver of contingencies. I want to talk about cancellation and deposit disputes. I want to talk about escalation clauses. I want to talk a little bit about fair housing. And then I want to end it by talking about just some tips, some things I've heard that I've put together over the years from my classes and from working with my clients, to things that are I've heard from a lot of really, really fine people. But before I do that, I'm going to look at the questions. So let's see here. Yeah, what? I'm not sure what that refers to. So I'm going to pass on the can we thank our services with a small gift? I would have thought yes, but from I have the complaint here somewhere. Let me see if I can dig it out. I'm going to read you the actual charging paragraph while I'm answering another question, because I just got this complaint last night. So the question is, I have seen on agent remarks implications of seller will prefer offers or will look better. Again, I've seen those with new homes, and I understand that you know, that it's the same thing with saying in a new house, you know, if you use ours, we'll give you better breaks. That I'm not qualified. I'm not an expert in RESPA. I just think that you get really close to the line, and the line includes treble damages, potential complaint by the Department of Real Estate. Can a tenant be asked to move without paying relocation fees? It depends. If they're kicked out for fault, you don't have to pay a relocation fee. But if it's a no fault eviction, and again, the rules probably should go back to the 1482 rules on July 1st. Then the answer is probably not. And again, whenever you're talking about a relocation fee, you really want to look at the local jurisdiction and what their rules are, because every jurisdiction is different. There's Adam, correct me if I'm wrong, last count there was like 140 different rent control moratoriums in the state of California. Can a tenant be, okay, can a prospective tenant be asked on the application if they have an ESA or service animal? I don't think so. Great question. Wish we had Brandon on. But again, they're not pets, and I'm not. I would be very reluctant, Dana. It's a great question. You know what? I'm gonna look that up and see if I can get a better answer for you. But I don't think you should, because you can't ask for a deposit, right? You can't ask for a pet deposit. It's not a pet. You can't. What you can do is if you have a no pet policy and they have a service animal or a companion animal or something along those lines, then you can work out the whatever the rules are, cleaning up, barking, things of that nature. I understand we cannot waive the TDS, but can we waive the AVID? I was going to get into that right now. That's a great question, Sandy. The answer is yes. Oh, excuse me. No, not the AVID. I was thinking of the SPQ. You can waive an SPQ because it's a contract document. It's not mandatory. It says in the contract that if I provide you with the TDS, I will also provide you with an SPQ. That can be waived. That's not mandatory. An AVID form is not mandatory. The inspection is what is mandatory. The AVID form is the form you use to put in writing what the inspection revealed. I think you'd be nuts, personally speaking, to not use an AVID form because it's standardized. It's accepted all over the state of California. It's the standard of care. I'm going to give you some tips on filling it out in a minute, which hopefully you will agree with. If you don't, that's okay too. But I personally think that you should use the AVID form. It is not mandatory to use the form. What is mandatory is to do a reasonably competent, diligent visual inspection of accessible areas and to disclose in writing why the AVID form exists, what that reveals. And I want to kind of go over that. So let me read you just to show you how, in my opinion, how nuts the department can get sometimes. And obviously I'm going to change the name to Jones and Smith. On or about blank date, Jones made a Facebook posting thanking blank escrow company and the individuals named for thank you cards and gifts to Total Wine, Starbucks, and they were scratchers, excuse me, I said Home Depot. The gifts were for the closing of property located at 3 different addresses. And it says code section, business info code section 101.77.4 provides in pertinent part, the commissioner may, after hearing in accordance with this part relating to hearing, suspend or revoke a license of a real estate licensee who claims, demands, or receives a fee or other consideration as compensation or inducement for a referral of customers to any escrow agent, structural pest control, home protection, title insurer, controlled escrow company, or underwritten title insurance. So do it at your peril. I think it's a mistake. But personally, I was shocked. I knew that was coming. Pardon me for stretching. I knew it was coming because I represent I've represented that firm in the past. I knew it was coming because we talked about it a couple of weeks ago. I was shocked to find it to be an accusation. I thought it would have been a citation. So film at 11 as to how that thing turns out, but it's very, very sad. So let me talk to you guys about some risk management stuff. And will the new RPA have boxes to indicate the type of property the contract is covering? It's presumed to be a residential agreement. If you're talking about a different type of property, then you would check off the appropriate box. There's a paragraph that references all the different addendums, which are now actually full-blown purchase agreements. Check off the box for the addendum you're going to use, and then you would integrate in the addendum. I think that answers that question. And then again, under current law, because I see it here, that if you're gonna evict a tenant because you've gone into contract, that's okay. but again, keep in mind that the rules keep changing, and I know your property management people are meeting tomorrow, and they have a really good speaker. I would hope that she would provide some good information. So let me look for my presentation on this topic. Okay, so Adam and a couple of the other directors and some directors at another board brought to my attention some time ago that Zillow and some others were joining the board and were using their own forms to significantly modify the contract. I don't remember if it was you, Adam, or somebody sent me the actual form, because I'm not a realtor, I don't sell real estate, and I took a dive into it. And a couple of things. Number one, so I want you to remember this, because I hear a lot of talk about, and again, it's not, Zillow is a member. Whether they're a member of CRMLS, I believe they are. I don't know if they're a member of a particular board of realtors. I believe they are. I don't know, Connie, if they're a member of your board, but I know they're a member in some boards. Bottom line, that means they're treated no differently than any other real estate office. That means that they comply with the MLS rules, and they comply with the Code of Ethics. And of course, they comply with California Department of Real Estate regulations. So that's number one. If you see them doing something that you think is a violation because you've actually read the Code of Ethics, or you've actually read the MLS rules, and you think that they're violating those rules, report them. Just like you would report Caldwell Banker, Remax, Rancon, Mary Smith Realty, any other real estate company, report them. Let the real estate, let CRMLS handle the MLS violation. If it's a Code of Ethics violation, report it. You have a great group of people on grievance, and you have a great group of people hearing these cases, and they'll take it up. And if there's a violation, Zillow will be treated exactly the same as a one-person office in Temecula. It's no different. But they do business differently. Not necessarily unlawfully, certainly, but differently. Whether it's a better mousetrap or not, I don't know. That's up to the consumers to decide. They have a contract, and I've seen this type of situation over the years with new home sellers that use their own contracts, and the law hasn't changed. You have your CAR forms and forms you're familiar with because of your membership as realtors, with CAR forms, and of course, some of you even have your own office forms that you're familiar with. That's not practicing law without a license. You didn't draft the forms. You're not interpreting the forms for your client. You're simply using forms that you've been trained on, and you're checking off boxes, filling in blanks, and that's not considered a violation of any rules regarding practicing law without a license. If you were to use a form, let's say, for example, you get a counteroffer and it's with a Zillow counteroffer addendum, you need to be really careful. Number one, those forms are written not from a neutral standpoint like the CAR forms, but they're written basically to represent one side of the transaction. They contain with them a lot of areas that, if you do have a law degree, if you are trained, great. But if you're not, and you miss something, you've exposed both your client and yourself to a world of hurt. Let me give you two examples of the Zillow contract specifically. And again, they may be changing them. They may do different things. But again, I'm not picking on Zillow, because like I said, they have every right to be treated just like everybody else. But I looked at their contract, and there's a waiver in there of certain disclosure rights. You always need to be careful about that. There's a waiver of any disclosure that, to the fullest extent of the law, is not required, and that has two basic problems. Number one, your client is now getting a property for which there may be no remedy if, in fact, the property isn't what was disclosed. And the seller may assume they don't need to disclose as much because they don't have to fill out these forms, right? So you end up in a situation post-close where now the buyer has a property, they're finding out all these things that would have been told to them in a standard SBQ and all of that. Then you couple that with the proliferation of waivers of inspection contingencies, and you've got a lawyer's field day. And that's why risk managers are saying things like, we expect a tsunami of litigation coming down the road, right? Because you start looking and you're connecting these dots, you might end up with some real significant issues. Another thing that I'm concerned about is practicing law without a license, right? You owe your duty to your client, right? And if you're telling your client, well, we don't have a choice, we've got to do this or we don't get the property, while that may be a true statement, you better make sure that you've sat down and thoroughly explained, look, buy an hour's worth of a lawyer's time, do this, do that. My company lawyer is set up to, or we've written our company lawyer has written a piece on these forms, or whatever it's going to take to get the burden off of you, because under Article 1, you have a primary duty to your client. Under Article 11, you have a duty to be competent. Under Article 9, you have a duty to understand the things that you're putting in writing and having your client sign. And last, but absolutely not least, under Article 13 and relevant provisions of the Business and Professions Code, thou shalt not practice law without a license, right? So be very careful about that, because again, you're familiar with the CAR forms. You've been trained on them. You understand basic disclosure law, but all of a sudden now you're being asked to waive this. The other thing I saw in that particular contract addendum was the buyer was waiving, to the fullest extent of the law, all of the remedies that they would normally have in the event of a seller's breach of contract, other than the remedy to get back their deposit. And again, if you miss that and suddenly the seller decides that they're not going to close, or that you're not going to they're not going to perform in whatever way, and you're limited, and I'm not sure it's an enforceable agreement, by the way, and there's a lot of argument that in my world that these are not enforceable, but let's assume that they are, or certainly that you've bought your client the hurdle of having to jump over these releases and restrictions. You know, is that something that's really in your client's best interest? And if you miss it or don't know about it. Now, I see a question from Shauna that I want to answer because it's a good question. So you get a Zillow offer on their form, you don't want to use Zillow. Do you have to accept it? You have a duty, and so do they. Everybody that's a realtor has a duty to objectively present all offers and all counteroffers to your client, not your decision to make. Your job is to counsel, and your job is to help facilitate. It's my decision, right? If you've told me I have an offer here from Zillow, or I have a counteroffer that I don't think is in your best interest, then you can decide how you want to handle it. I understand the practical aspects of this. I'm not living in a Pollyannic world, so I do understand. But again, we know that we're going to see litigation. My goodness gracious, we see litigation over cracks in driveways. We're going to see litigation, and you don't want to be stuck in that situation. So bottom line is do whatever is feasible to make sure that you are protecting your client. And again, and I'd be happy to talk to the Zillow lawyers. I'd be happy to talk to a Zillow agent. I don't have anything in the world against Zillow. I don't own any property in California, so I'm good. But I will tell you that I know that CAR lawyers are having some conversations with them to maybe try and tone some of this down. So we'll see what's happening. So, anybody been waiving contingencies lately? I understand that that's a fairly common practice nowadays. I wouldn't do it when I sold my house, but I was talking to Ed Zorn yesterday, and apparently it's an incredible. And I'm joking because I know it's a common practice because of your market. So, what are we talking about here from a liability standpoint, and what should you do? Okay. Nikki, message me offline about your question because I want to talk to you about it separately, Nikki Gorman, okay? All right, so what is a contingency? My goodness gracious. Let's talk about what it is first. What are you waiving? First of all, is it legal to do so? Absolutely. We'll waive every contingency known to man. There's 9 of them in the RPA. We'll waive them all. You can waive the appraisal contingency. You can waive a inspection contingency. You can waive all the contingencies. And if you feel that's in your client's best interest, then you sit down with your client, you go over it. What are we talking about? We are talking about conditions precedent to the duty to perform. So what does that mean? I have put down a $50,000 deposit, which is 3% of the purchase price. I have waived all my contingencies. The 3 to 5 days for cancellation based on the transfer disclosure statement has expired. We are down the road in a position to close, and I cannot or don't want to close because the appraisal came back low, because the property isn't inspecting the way I wanted to inspect. There's a lot more wrong with it. That one I'll talk about a little separately, or I can't get my loan on time and I lose my deposit. Basically what happens is the risk of loss of the deposit, instead of waiting 17 or 21 days to see if the contingencies are removed or if the transaction is canceled, immediately becomes something that is an anticipated benefit to the seller. So a couple of things to be aware of. First of all, CAR has all kinds of cool stuff on its website, quick guides to contingency offers. It's legal. It means that the duty to close becomes mandatory. Can a waiver lead to broker liability? Certainly, if you do what? I've seen it go both ways, and I'm sure you guys have too. You know, where agents are talking their buyers into waiving contingencies because it's the only way to compete. That may be true. I'm not a realtor. But here's the deal. The law hasn't changed. The duties haven't changed. You need to sit down with your client, probably at the get-go, and say, look, this is a tough market. We're seeing 10, 15, 20 offers on houses. We're seeing properties, escalation clauses and things going up in value. And, you know, among other things, buyers are demanding what's been going on in San Francisco for the last year, which is non-contingent offers. Here's what that means. Have a checklist, do something, give them the CAR quick guide form, which explains that. I just wrote a newsletter. I'm going to check with my office to find out if it's been sent out yet. I wrote a newsletter as simple as I could make it. It is not sophisticated at all on waiving contingencies. Give the buyer something in writing explaining, and I really like the CAR quick guide, explaining what we're talking about here, what's going on. Look at Daniel. You guys have the best staff, I swear to God. So Daniel's just posted that quick guide for you. And so take a look at it, hand it out, give it away. It's worth it to you, and then confirm in the file that you did exactly that, so that it becomes the buyer's decision. I want this house. I'm willing to take the risk, right? Now, a lawyer may be able to figure out how to get you around the waiver. That's always a possibility. But again, I'm concerned about 3. One is the appraisal contingency waiver, because now you're going to be paying, you're going to be obligated to close regardless of what the property comes in at, unless it's horrifically different, because then you can argue there's been not been a meeting of the minds. And I'm really, obviously, the loan contingency, and then of course the inspection contingency. And in that context, if the property comes back incredibly different than what was disclosed on the TDS, you might be able to make an argument. Ellen, to answer your question, the answer is yes. You may be able to get out of a contract if the difference is, quote, too high. And then what I'd like you to do now is to come up with an agreed amount that's, quote, too high, either by number or by percentage. That's the problem. It becomes a very ambiguous situation, and now you have a judge making that decision, and the burden will be on the buyer to prove it was too high, and therefore there was not a meeting of the minds. Any other questions about that issue? Because if not, I want to jump in to an area that was really sad for a realtor recently. So the contract has cancellation rights, right? It's not without the ability to cancel. The seller basically has three. If the buyer fails to remove the applicable contingencies, assuming there are some within the appropriate period of time, after first giving a notice to perform, the seller can cancel. The seller can cancel if the buyer doesn't close on time after giving a demand to close escrow for a minimum of 3 days. The seller may also cancel in the event that the seller has reserved unto itself a right to find replacement property and cannot do so in good faith. The buyer has about 5 grounds for cancellation. Number one, the seller fails to provide all of the things the seller is required to provide, and after first giving the seller's notice to perform, pretty rare, but can cancel. The buyer can cancel if there are contingencies, and before the contingencies expire, they decide to terminate the contract for so long as they've acted in good faith. They can demand to close escrow, and if the seller refuses to close, they can cancel, or they can sue for specific performance. If they get a TDS they don't like, they can cancel so long as they act in good faith. And then lastly, if they get an amended TDS, they can cancel. Okay, that's it. I can cancel. Now the question is, okay, somebody's canceled. Who gets the deposit? Well, if you've waived all contingencies, good chance the seller's gonna get. But let me tell you about a case that happened. I didn't handle it. A friend of mine that handled it. So buyer enters into escrow. So I prepare an offer. I send it over to one of you. Let me pick somebody that asked a really good question. So I send over to Ellen an offer, and I'm representing the buyer, and the offer or the counter offer, however it works, is accepted. We now have a contract. Day or two later, the buyer looked at some other properties, just out of curiosity, found one he liked better. So I, in my ignorant bliss, say to him, well, that's fine. You have all these contingencies, so I guess you can change your mind and we'll go ahead and cancel. And so that's what they did. And the deposit was about $70,000, which was not more than 3% of the purchase price. The seller was pretty sophisticated, asked his lawyer, is this right? You can just change your mind? The lawyer said to the seller, well, there's a requirement in California that you act in good faith. In other words, if there are contingencies, that does protect your deposit if you're the buyer, but you have to act in good faith. You have to order up the inspections. You have to make a good faith effort to get the loan. You have to do the things that are anticipated by all of you in performing and the due diligence that's necessary. And you have to act in good faith. So the seller refused to deliver the deposit, and they went to mediation, didn't settle. They went to binding arbitration, pursuant to the terms of the agreement, and the court agreed with the seller. Court said, nah, you can't just change your mind. You got to act in good faith, and awarded not only the deposit to the seller, but also awarded him an additional $50,000 in attorney's fees. So be careful. Couple of tips that I'd like to share with you, just because I like you guys. Number one is don't give an opinion that your client's going to get back the deposit or that they can safely cancel. You're probably going to be able to use some general language. Well, usually if contingents remain in effect and because we did so much work, usually you're going to be able to get the deposit back, but it's going to be up if the seller won't agree to release it. You're going to have to either go to small claims court if it's less than $10,000, or you're going to have to, go to mediation or arbitration if it's more than $10,000, and it'll really be an argument for an arbitrator, mediator, or a judge. Don't give an opinion about whether somebody's acted in good faith or bad faith. It's a highly factually intensive and therefore case-by-case analysis of good faith. Clearly don't give an opinion as to who is actually entitled to the deposit, and be careful what you say in writing regarding the deposit. Okay, see, I have a couple of questions here. Is CAR adjusting close of escrow +3, sellers not moving out? Any remedy to help sellers? No, not that I am aware of. I think you're talking about sellers not moving out. There was a case in Riverside, and everybody got themselves all worked up. That case was not about tenancy. It was about something completely different, and the seller lost. Ended up settling. It is a breach of contract if you have a close of escrow plus anything less than 30 days, so 29 or less. It is a breach of contract for the seller to move out. The problem is finding a place to go exercise your remedy, right? The courts are opening back up again. Things are hopefully moving, but for this last year and a half or so, we haven't had any courtrooms, right? Good luck in finding a judge that can take your case. If cases are being handled, I did a trial last week, just a one-day thing. We did it by Zoom, okay? So there's all kinds of things that are happening. So the problem is, if I'm the seller and I sign an agreement to be out, and hopefully you've used the seller in the SIP form, which is a very good form to document your facts. That's the SIP. It is to be used to document the close plus any period of time less than 29 days. So long as you've done that, you should be fine. It may take a while, but the seller is going to be paying damages, and because the seller hasn't necessarily gotten all their money, there may be ways you can collect. In my case, the escrow company wanted the deposit. They got a portion to avoid court. I'm not sure exactly how that happened, Betsy, but if you read your standard escrow instructions, they're entitled to a daily rate, and they're also entitled to compensation if they have to file an interpleader action to turn the deposits they're holding over to the court. Can conversations with clients be recorded for the record? Only if they've given you that consent. In California, to record a conversation with anybody requires their express consent. That's why, like when you make these phone calls and it says that we're recording this for quality assurance, blah, 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 If you stay on the line, you're agreeing, right? That's going on. Proposition 19, there are going to be, and Adam probably knows better than I haven't really paid a lot of attention, but there's some statutes that are being changed to delay certain portions of it. And there's a couple of really good, in fact, I'll give you the name of them. There are 2 Q&As, one on property tax and one, it's called Proposition 19, Property Tax Exemptions from Reassessment. Well, actually, that's one form dealing with all of that, including tax and all the rest. That's a Q&A that was done on March the 5th, and they just revised it. So that, take a look at that. And CAR has a lot of stuff because CAR was the primary sponsor of Proposition 19. So you can get that information, Andy, from CAR's website. What about seller in possession time 60 days, then refuses to move out? Different situation. Because now it's actually a lease, and now, but again, if it's about rent, that's one thing. But again, the eviction is based upon the fact that there is a breach of contract. So that's a little bit different scenario, and it's a case by case, Joan. But more than likely, the buyer would prevail, and it could even be a fraud claim if the seller knew all along they never intended to move out. Can escrow hold sellers? Well, if you're gonna do, the question is, can escrow hold seller funds until seller moves out? Yeah, it's called a deposit, right? You can hold money based upon the fact the seller's remaining, and then that money's turned over. Sure, why not? If seller required to disclose a crime that happened at the property between neighbors when she sells it, there's lots of areas. If you look at the transfer disclosure statement, the SPQ, about neighborhood issues, neighbor issues, criminal issues, specifically criminal on the property. If the neighbor's still around, I would suggest you disclose that. I just finished a case, great set of facts. Get a call from my broker, has 400 agents, says, hey, I got a problem. We're selling a house and we just got a disclosure. Apparently there was a party, and it was a drug type party, and somebody overdosed in the bathroom and died. So they dismembered him and put him in the backyard. What do I need to disclose? And we did some research and went through what we thought would be appropriate. So these issues do come up. If the crime was between a tenant and a neighbor, you know, my attitude is, without knowing all the details, Ellen, I'm saying disclose it, but it's really not going to affect anything because people are gone more than likely. But again, I don't know what the crime was. Was it a fist fight? Was it an assault? Is it a fair housing issue? Somebody calling somebody, you know, racial epithet? What is it? Do we have to disclose a homeless person or homeless encampment nearby? I believe the answer to that is yes. Let me get into that in just a second. So let me talk about some tips because I'm going to run out of time. I'm getting close. And if I have time at the end, I'll answer some more questions, and I'll talk about some other things. But here, a couple of things. So I was at a meeting with other defense lawyers, and we were looking at you guys, and we're really your friends. We really like you. We defend you. I don't sue you, right? You got to slow it down. I don't know if you agree with me. Things are, from what I can tell in California and here, this market is no different. In fact, the town next door to us called Murfreesboro, one of the 10 hottest properties in the United States. Where I live, it's ridiculous. I bought this property about 2 years ago, and it's already gone up in value substantially, even though now there's a house on it. Which obviously that added tremendously as well. The market's hot in lots of different places. It's kind of cold in some others. So slow down. because you need to be careful about how you're documenting things. And so let me find my notes, and we're going to talk about this right now. So again, you guys are moving at a pace I've never seen before. Carol, you've been doing this for a while. Let me see who else I can see that I might know. I know a bunch of you. There's Patty. You've been doing this for a wee bit of time. Susan, one of the smartest people on the planet, been doing this a long time. A bunch of you. You guys know this market is really, really fast. The trouble with that is none of the jury instructions have changed. None of the laws have changed. None of the duties under the Code of Ethics or elsewhere have changed. You guys got to take your time. Document your files more carefully. So I'm just going to go through a stream of consciousness here. I wrote down, this is my PowerPoint presentation for the day. And I told Connie, I haven't had time to do it because frankly, we just moved in. I just got our furniture, and I'm, cheerleading my wife as she opens boxes and puts things away. But I'm going to put all this into something and get it to Connie. So she has a list of all the nice people that have been here, and we'll get this posted. But you got to develop a strategy with your client and provide as many. I know this sounds cheesy, but you guys got some great advisories out there, and you're not using them to the full advantage. You need to get them to your clients as early as you can, whether it's the disclosure information advisory on the seller side, the homeowner advisory on the buyer side, the statewide advisory. Make sure that you get these documents to your client and that you give them adequate time to read them. Develop policies inside the office and follow them. Develop checklists and follow them. Again, there's so many things being missed right now, not necessarily by you guys, but in general. Control the pace the best way you can. Talking to a really good buddy of mine who's tried a couple of hundred cases over the last couple of years, over the last couple of decades, I should say. We were talking about, the fact that buyers are buying property for sometimes many thousands of dollars over what their appraised values are, or even what any reasonable person would think they're worth. I believe we can anticipate down the road going to be a lot of remorse. As the market starts to plateau and maybe even shift, there's going to be some remorse. If that's true, and I don't know that, but if it's true, who are they going to look to take out the remorse on, right? Well, you should have told me this. You could have said more. You could have done differently. You didn't. You didn't represent me properly. And I think you should give me money. So anticipate that remorse. Let them know, don't make emotional decisions, right? You got to deal with your client's emotions. I know all the time, right? What do you mean I'm only going to get this much money? Bill down the street got twice as much for his broken finger, so you got to deal with those kinds of things. Give them some comparable data, because, and Dave Bright, who's a really great lawyer down in Escondido, he's retired now, he's a mediator, made the point that, this market is shifting up. So who's going to be remorseful now? The seller, because they could have held out for more. But down the road, who's going to be remorseful? Buyers who paid too much, right? So all you can do is take a snapshot in time of today. This is what the market is looking like today. Adam does a great local realtor report. Give them stuff to make sure that that they are aware. What we're doing is based on whatever you're dealing with right now. Be very careful today about dual agency and dealing with competing buyers. If you're in a good sized office, you may be representing the buyers, but someone else in your office may be representing competing buyers, and you both share a broker. So make sure that your office has good policies in place, because if I'm being represented by Carol and somebody else is being represented by Sylvia, and we're in the same office, there's a fiduciary duty issue there that needs to be dealt with. If you're acting as the dual agent and things are spiraling the way things are spiraling, you better protect yourself. And I'm going to talk about that in a second, about some things you might want to do. Be careful about elder abuse right now, right? A lot of sellers are, moving, selling their property. Elderly people are retiring. I'm an elderly people, right? And just because I'm allegedly
Sorry, John, I think you got muted.
years. There we go.
There you go.
All right. My wife's been trying to mute me for years. It hasn't worked yet. So here's the deal. She's out picking up our grandchildren for karate, so I can say whatever I want. But just be careful about seniors right now. Seniors are considered to be anybody above 65, and the damages are trouble. If there's something that was not done correctly, put as much as you can. And I know how busy you are. I had one of my fondest clients tell me the other day, "You're telling us to do all this. Where do I find the time?" Well, make the time. Because if I have a conversation as a buyer with Carol, and Carol, you're the first person I see on my screen, that's why I'm picking on you. Okay? Plus, you're a great person. But if I have a conversation with Carol, we don't document that conversation. That conversation never took place unless it hurts Carol, right? That conversation didn't, I don't remember that conversation unless there's a witness or some corroboration or something in writing. So figure out what you can do to document important conversations. Save your texts, save your emails for sure, and document your file as best as you possibly can. Because again, if it's verbal, I don't care about it. All right, some specific other tips that I want to go over with you. Remember the basic rule that's in the jury instruction. If you have actual knowledge of material facts, you must disclose them. If you have material information that you have, which are different than facts, you haven't verified them, you don't know if they're true facts, still must disclose that to your buyer, because you have a fiduciary duty to disclose all material information. Make sure, and that's why I like the new RPA, what does go with the property, what doesn't. Again, make sure that's pretty clear, that you don't get into that kind of a situation. I've seen issues lately because people are operating so fast. Yeah, Vicki, I know we're all elderly now, and I know, Karen, that we all are operating too fast. I understand that. The bottom line, though, is that people are checking off boxes and things without even really knowing what are the utilities available, what are the structural defects, and make sure that just because I've waived my inspection contingency doesn't give the seller the right to not disclose material facts, or for you to not disclose what you see during your visual inspection. Has there been a death on the property? That, because of COVID, has come up more than I've seen before. Are there ongoing disputes with neighbors, with the POA? What are those disputes? And get as much information into your buyer's hands as possible. Are there nuisance concerns? Are there noises? Are there smells? Are there zones, drop-off zones? Are there cannabis facilities nearby? Are there parking or storage issues, right? I live on a circle. Those trees back there, it's a big giant, I don't even know how big it is, circle. And the issue the other day was, could the semi come down the street to deliver our furniture, right? Because it's a very small street. So are those issues out there? Because again, people are going to be looking for legal action, and I'm very concerned. What groups have control over your property, right? Obviously, what jurisdictions, cities, counties, POAs, architectural control committees, right? Who has control of the property? Are there public services nearby? I was standing outside the other day and with my grandson, because there was a deer in my backyard and we were trying to see it without scaring it away, and we heard a train whistle go. I had no clue. There were about a mile away is a train track, and 3 times a day the old whatever it's called goes by and the whistle blows. Now that's not a big deal. That's not something that materially affects this property. It's actually kind of cool. But are there services? Some of you live underneath the March Air Force Base pattern. That doesn't happen all the time. What about those of you that live up in Tanaha and get woken up because they've decided to play military games over at Camp Pendleton? Is there something close by? Farms. Dave was telling me about a case that he defended. The prevailing wind was a certain way, no problem, except one day the wind shifted. And that chicken ranch, not too far away, but not necessarily visible because it was not part of the main thoroughfare, suddenly made sitting out on the patio, how do we say, unpleasant, right? So are you aware of that kind of stuff? I thought a gal in our risk management class the other day, not class, meeting, made a really great comment. I had to tend to, I mean, I understand what she was saying. She said the agent's visual inspection form is a lie. What did she mean by that? It's not just a visual inspection form. What do you see? What do you hear? What do you smell, right? It's more than just an inspection of what you see. There's a lot more that goes into it. So be aware of that as you're walking around, seeing, smelling, hearing, etc. Be careful, and you've heard me say this before, be careful with the choice of your words, right? Stay away from adjectives, stay away from adverbs. It's not a water stain, it's a stain. It's not a foundation crack or a settlement crack or a stucco crack, it's a crack. Stay away from numbers, right? Man, maybe you saw 5 cracks, but maybe there are 20 cracks you couldn't see. Stay away from things like putting in your AVID form, except as otherwise noted, property looks to be in great condition. The AVID form is not a, pardon me, the AVID form is not a sales document. It is a disclosure document. Don't sell the property, you're already in escrow, right? You don't need to do that. Just leave that kind of language alone. If there are yes boxes, explain them, right? We just went through this. We lived in our house for 37 years. When you are asked a question, has there ever been any repairs? Oh my gosh, how do you answer that question, right? You answer it with CDs, discs that you've scanned, 30 years of repairs on. You do whatever you need to do. You say, yes, take a look at this, right? You do whatever you have to do. You think, because that half hour that you think could save you years of litigation. And think of all the time, money, emotional energy that goes into defending a lawsuit. Answer all the questions on both the TDS and the SBQ, right? Make sure your client doesn't just skim over them. That's why I love that disclosure information form that CAR came out with last year, because the burden is off of you onto them, right? Read this. You got any questions? These are the CAR lawyers telling you how to fill out these forms, right? Be careful about, and I know right now selling is probably different than it usually is, because houses are selling themselves from what I've been told. But the more aggressive, and this is a statistical fact, you can trust me, I'm a lawyer. The more aggressive you are in the language you use in marketing your property, the more standard, higher standard you're going to be held to in defending that property if there's a lawsuit over disclosure. Give yourself some fudge room. It's not the best house in the neighborhood. It's not the largest, right? That's what got Mr. Haricki in trouble, calling it when his agent or the agent called it the largest house in the area, right? Just give yourself a little bit of fudge room. I don't know if Connie, if you remember, I don't even remember if you were the CEO at the time. We got a letter from the attorneys up in San Francisco that represented jacuzzi, because a lot of agents were saying the house comes equipped with a beautiful jacuzzi. Well, it's not a jacuzzi. It's a spa. It's a whirlpool. Stay away from brand names unless it really is a jacuzzi, right? Because that can get you into some trademark law right now is off the charts. Again, these are shifting values. You need to make sure your client understands that it's not you setting price. It's their setting price, and appraisers are going to give information about what they think values are. You don't set values. You can't do that. If your seller wants to remove fixtures, remove them before you start marketing the property so it doesn't become an issue. Give your buyers adequate time to go over documents. You're going to be giving them a very large package of disclosures. Give them adequate time. Don't diagnose problems you're not qualified, right? If you see a problem, say what you see, say what you hear, say what you smell, but you're not qualified to diagnose that problem. And then take a look at your insurance policy. One of the people at my meeting the other day opined that California is going to have an insurance crisis coming up fairly soon. Well, I didn't get to everything, but I got to most things. I do want to answer a few more questions. I don't know, Daniel, can you take me to where the last question? Let's see here. Can buyers still get out of a contract when they see defects they didn't like, even if they remove the inspection contingency? It depends. You can always cancel the contract. The question is, will you get your deposit back? And it just depends upon a lot of different factors. I hate to be lawyer-like in that answer, but the odds are, yeah, you can cancel in good faith and maybe argue that the seller failed to disclose or there was a lot of meeting of the minds. But the more you get into that, the more open you are to a judge making the wrong decision or a lawyer stepping in and, you know, gumming up the works. So stay away from that if you can. And the same would apply, Denise, at the walkthrough, that you know, when you're doing your, you know, we did 2 walkthroughs at the house in Canyon Lake, and we're still, I don't know, I'd show you, but I don't know how to move around here, but you have blue marks all over this house, right? I mean, you're continually looking for stuff, and even after you've moved in. And then of course you got to worry about, have the movers damaged anything? Have there been scratches in the flooring and stuff like that? But I am going to go ahead, and I don't have time unless you guys want to stay late. I'm okay with that. I have, I'm just going to go see my grandkids do karate. but that's not for another hour or two. So I can stay and talk about escalation clauses if you like. I can give you a quick 5-minute overview of them. Let me see what other questions we have here. I would love to hear your thoughts on escalation clauses. Okay, Wendy, since it's you. If the buyer agreed the property is an as-is and turns out the seller did not disclose the leak, can the buyer? Yes. As-is means I don't have any legal obligation to fix it unless the law requires me to fix it, whatever that might be. Some jurisdictions have requirements to fix certain things, et cetera, et cetera. But no, if that doesn't give, and that's what I get concerned about when I'm looking at all these inspection contingency waivers and all that, is this false sense in the seller's mind, hey, don't worry about it, right? I don't got to disclose it because I'm selling you this house as is. It's as disclosed, right? I'm telling you, I got a leak wherever, I didn't see the whole thing. It's like a leak in the kitchen. I got a leak in the kitchen. Okay, you got a leak in the kitchen. I'm either going to buy the house and fix the leak if I can't negotiate with you for some repair, or I'm going to cancel, right? That's what that means. So Harrison, great question. The answer is yes. Now, if you've waived your inspection contingency, but you can establish that the seller was aware and failed to disclose, that doesn't necessarily go to the deposit as much as it goes to the potential fraud the seller has. And in that context, probably going to get the deposit back. So we talked real briefly about escalation clauses. I know there's a few more questions. Daniel, is there a way that I can get a copy of all these questions so I can, when I send Connie my summary of today, I can answer the rest of the questions we don't have time for, because I don't want to keep people, and I know we're going to lose a few people. Haven't lost too many, but we could. So
Yeah, I'll get you a list of all
give
the
you my
questions.
favorite escalation clause. I got this from one of my clients, and I just love it. Let me see if I can find it. Okay, here it is. Oh, right there, right in front of me. Okay, so on the addendum, it says, just one line, buyers to pay $2,000 over, best and high offer in hand, sellers to provide proof. So at least one of the things we will tell you, make sure that you negotiate to get proof that it isn't just the seller's word of the price. What's missing here, Wendy? I don't know how to get a hold of you, but I'm going to tell you what's missing. Where's the cap? $2,000 over what price? Is there even a meeting of the minds, right? If Adam and I are negotiating and I say to Adam, I'll pay you $2,000 over the best price you get, right? One of the elements of a contract is what? Price. Parties, price, subject matter, blah, 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 capacity, and there's one other element which my age is preventing me from remembering right now. So, price. Do we have a contract? There's a lot of lawyers, there are a lot of lawyers that question whether escalation clauses in some format are even going to be negotiable. But clearly, if you just represented me and we agreed to this, and suddenly that purchase price comes in at far more than either one of us anticipated, and the seller is acting in good faith and can prove that there was a gradual escalation to that number, I've just contractually agreed to pay $2,000 over that price. So you want to make sure that you put a cap so that there's some basis. It's no different than when we used to talk about putting a cap on agreeing in advance to make certain repairs, right? You don't ever want to give anybody else a blank check. So I think that's probably not a bad idea. Is there a floor price? So again, I think what I'm going to do is I've got a whole bunch of material that I downloaded for a client that asked me some questions. But the bottom line is, really, at what point does it get stupid? I was talking to a client in an upscale area day before yesterday. What's today? Today's Wednesday. No, today's Tuesday. So this was probably yesterday. Wow, time flies when you're having fun. They upbid at $900,000. I can't even fathom. You listed the property at X, and somebody was willing to pay $900,000 more than that price. I question the competency of the listing broker in the first place, frankly. But beyond that, what are the components? And then certainly there are benefits if it's done correctly and it's done in some manner that gives an objectively verifiable way of confirming how all this is arrived at and is enforceable for that reason. There are some benefits, but clearly there can be some tremendous downsides to this. And so you want to be careful that you put some time elements in it, that you put some caps on it, and that you give your clients some wiggle room. Well, Connie, Adam, I think I've used up my time. Sylvia's putting all kinds of cool stuff on the site here. I haven't got a clue how to download it, but it's some good information on eviction moratoriums and the like. We fully suspect that you're going to see some significant changes. Adam, I haven't heard a whisper that they're looking to extend anything past the June 30th date. So more than likely AB 3088, which is the eviction rent moratorium, and the and SB 91, which extended that, probably going to sunset along with everything in it on June 30th. And then you go back to 1482, and which may, Connie, I'm thinking might not be bad to have the property management committee come and do a revisit. We've been away from 1482, which was the new rent control that went into effect in January of 2020, to come back and revisit that, because everything now that's been stayed or delayed now comes back and becomes reality again. And I suspect, and I don't know if there's any other lawyers on this panel, but I fully suspect the courts are going to be inundated with litigation down the road. So be careful, take your time, always tell the truth, do the right thing, and hopefully, I don't know when we're doing anything again, but I'll do the best I can to keep you all updated. And if you're in Nashville, come by for some moonshine. I got some for my birthday, so I haven't touched it yet, waiting for Adam to show up because he's the only person I know that can probably handle it, or Gino probably could too. But come on by for a visit, and we'll meet again. And I'll look at all these questions. Maria, I just saw you posted a good question. I'll take a look at them, and I'll make an effort toward the end of the week to get back and answer some of these questions, okay? Is there anything else? Connie, you want to say anything? Good. Adam, anything going on that you want to talk about? No? Walter, how about you? Anything cool? Just took a 2-hour break, huh? That's neat. All right, guys. Then, unless there's nothing else, we'll bid you adieu until the next time. You're looking at each other. Connie,
thank you, John.
Thank you. Oh, hi, kiddo. How you doing?
Hey, John.
Good.
All right, guys. I'm looking forward to seeing you all again. I'll be out again next month, and I'll be coming out pretty regularly because I still have a son, 2 sisters, and hundreds of friends that live in the Temecula Valley area. So I'll be back. Not that you're looking forward to it, but just so you know, I will be back. So
Well, let us know.
Thank you. Ah, there she is, Mrs. H. How you doing, kiddo?
Good. How are you, hon?
I'm good. So I'll bid you all adieu, and then I'll take a look at your questions. And Wendy, if you want to give me a call, same cell phone, I'll go over the escalation stuff with a little more detail. Take care.
Thank you.
Bye-bye.
Thank you, John.
Bye.
My pleasure.
Thank you, John. John.